Hi, I'm John Rabel, the founder of Launch, which is a legal and business advisory firm for small and mid-sized companies. And today I thought I'd talk a little bit about contracts, specifically service agreements. So generally, a good rule of thumb for business is that you should have a written agreement or contract for every relationship you have, both internal and external. And so if your company provides a service, for example, you're an accounting firm or an IT consulting firm, or consulting company. You're providing a service, and so you'd want to have some sort of service agreement that you have your clients or customers sign when they hire you to do work for them. It's a really important step to take in order to protect yourself, to protect your business assets, and to sort of make sure you can proactively address any potential issues. And if a dispute does come up, you've got something in place that you can sort of fall back on that can help you figure it out and get things moving in the right direction. So specifically when you think about service agreements, what information needs to go in there and what needs to be covered in order to have a good solid base for the relationship going forward. So you want to think about a couple of things. One, describe the services that are going to be provided. Describe who's going to be providing those services. What's the cost or the payment terms involved with the services being provided? What's the time frame for the services being delivered? You want to make sure and spell that out. These common things that people disagree on from a verbal standpoint, so getting them in writing is going to be very important. What type of quality control might there be over the services, and how will you determine the standard to be applied and whether or not the services are being provided at the level they're expected to be provided at? What type of cancellation terms are there? Who can cancel? Can anybody cancel? Is there a time frame with canceling? Can you only cancel if there's a breach? What's the procedure if something goes wrong? You can sort of set up a dispute resolution mechanism inside of a contract, maybe in your advantage to try and avoid going to court altogether with an arbitration clause. Or maybe you want to waive a jury trial and just have a judge handle it if a dispute ends up in court. Things to think about that might be cheaper and faster to resolve an issue that comes up. Then you don't have to bicker back and forth about it. It's already going to be expensive if you end up fighting over the terms of an agreement. So I think if you run a service business, you want to be really cognizant of how important service agreements can be, how much they can protect your business, and then really understanding what needs to go in them and understanding the terms. One issue a lot of businesses run into is they have some agreement in place, which they may have pulled from an online resource. They aren't exactly sure what's in it, and it may not even be in their best interest. And so, things go wrong, an issue comes up with a client or customer, and there's a dispute. And then you find out that you don't have a service agreement that's really in your best interests, and potentially you're in a worse situation than you would be if you didn't have an agreement at all. So it's very important to make sure that your service agreements are customized to your specific company and to the specific services that you're going to be providing, really understanding what's in the agreement and how that contract works and benefits you. If you have any questions about service agreements, feel free to reach out. J Rabel, that's JRAB as in boy, IL, at launchstrategylegal.com or 804-442-6090.